Hey guys, Glenn Younes again from Corner Unit Media. Pleased to be joined now by Michelle Cohen from Ifrah Law. She's going to talk about a very important, but for a lot of marketers, very scary and maybe even very boring topic, which is GDPR, but it is very important. Michelle, thanks for joining us.
Hi, thanks for having me today. Happy to be with you.
My pleasure. It is a giant web that we are going to try to untangle in a fast few minutes here. There's going to be plenty more on the bone. But before we get into GDPR and how important it is and what it is, tell us a little bit, Michelle, about you and your firm and what you guys do, your background, and what you specialize in.
Sure. Nice to meet you and the folks listening out there. So I am a lawyer in Washington, D.C. I've practiced in the area of privacy. Oh, go Caps. Let's hope it's a win.
I know.
And when people are watching this, it's
we'll
a
know.
big win.
Yeah, we'll have known, yeah.
With Lord Stanley, maybe. So I've practiced in the privacy area for over 20 years, guiding clients through all sorts of means where they want to reach customers and contacts, whether it be telemarketing, email marketing, text messaging, participating in sweepstakes and contests and various promotions over social media, over regular media. And really my goal, as I've said for years, is to help clients reach contacts and prospects and do it in a way that keeps them compliant with the privacy regs and keeps their customers happy and interested as well. I have several colleagues here at the firm who also practice on the privacy side. We have various certifications issued by the International Association of Privacy Professionals, which, if you can believe, is already 40,000 members in a very short period of time. So you see the need for privacy guidance. I'm a CIPP, Certified Information Privacy Professional. We also have another Certified Information Privacy Professional specializing in the EU side, Nicole Cardell. And our firm is a boutique firm here in DC. Many of the folks come from the largest firms in the country, and we are Chambers ranked, which is a rating, very prestigious ratings company. And we operate right here on Pennsylvania Avenue and specializing in privacy, gaming, litigation, and governmental investigations.
That's wonderful. So we're talking with the right person. I'm a native Washingtonian, as is my family, for 125, 30 years. So it's good to talk to somebody from a local D.C. firm. That's great. By the way, the website is ifrahlaw.com if anyone wants to check you out, and we'll make sure we put that in the video as well, Michelle. We have one of our larger clients is actually a doctor's office in the Howard County area, urgent care, primary care, physical therapy, a lot of outlets. And so the privacy piece and the data collection has always been forefront in the mind at my agency here as I've been building it. And then that sort of dovetails into GDPR, which let's dive into it a little bit, if you will. And again, for those who are watching this and listening to this, it's a very complex matter. We're not going to get every single piece of this today. We will definitely point you in the right direction to Michelle and her firm. So if there's more information, you can please reach out to them. But we're going to try to chop up this giant, huge pizza into a piece or two that we can digest. So I guess first question, Michelle, is why GDPR in general? Europe, it's a European thing first. So I guess I'll lead into, with why. What is it and why Europe? Was Europe being taken advantage of by marketers? Are they a little bit less tolerant of digital marketing? Talk to us about the evolution of GDPR, why and what.
Right. So the laws in Europe are different than the laws in the U.S. when it comes to privacy and marketing. And while GDPR has just been implemented as of the end of last week, privacy laws in Europe are not new. They've actually been in place for several years. This is an update, and I think that the difference is that the U.S. relies on sector-specific regulations. So in the U.S., we've decided that healthcare, like you mentioned, financial privacy, like the Graham-Leach-Bliley regulations, and let's say children's data are special categories of data: healthcare, financial, and children's data. And for those, there are specific laws, and those are tighter than some of the other laws, like CAN-SPAM, which is general marketing, and that in the U.S. is an opt-out law. In Europe, they've taken an approach that they're not going to be limited to sector specifics. They want it to be broader, so it doesn't just cover healthcare or children's, though there are special provisions in GDPR for children's info, but they're going to take a broader brush on on data collection and data use, and really put the power back in the hands of the consumer. So unlike other places which might say, data is data, however we get it, in Europe they're saying personal data belongs to the person, and you, company, organization, have to disclose what you're doing with the data, and there's certain regulations as to how you use the data, and you're going to need consent or be collecting and using it under one of the other permissible ways for doing that. So they are less tolerant of just kind of random marketing, for instance, and they're really putting the power in the hands of the consumer to say, it's my data and I'm going to say how you're using it. That said, there is some talk in the law and in the discussions that the law is also supposed to help businesses, because instead of having to figure out what each country in the EU is doing, now there's a central law, and there should be some central guidance as to what's going on. So arguably, it's also to help businesses when they're operating in a digital environment across the whole EU.
Yeah, that's very interesting. So a couple things that leads to. You said it, but I'll sum it up. It seems to be this is a personal data control act, if you will. And then the other part is, while it seems so broad and vast, which leaves so many gaps open, you did make a great point about how it sort of covers all of the EU, because different countries in the EU could have different rules. So it's overarching. It's like broadly specific almost, if that makes any sense to people, but seems to be a personal data control act. Individuals now have more control over what's done with their data. Give us an example of data. That's email, that's phone number, that's any sort of touch points, tabs, however people want to categorize in their different systems.
Yes, the definition is fairly broad, so it would include, so the most basic personal data that we think of, let's say a full name. It would include a identifier, number identifier, like in the U.S. where we have a license number or social security. It would include that corollary in the EU. It can include a photo. It's really meant to include anything that can be used to identify a particular person.
Okay.
So I would say if you're in doubt if something is personal info, in the EU, it's probably going to be personal info. So it is meant to cover a lot. And then I didn't want to necessarily skip to your question.
No, go ahead.
But it's funny that so many of us, I'm sure you did and I did, got all these emails last week. And we still get them this week about
what was the date? The 23rd or the 25th, right?
The 25th.
Yeah.
The 25th.
May 25th, 2018, for those watching at a different time.
Right. And so you probably were thinking, what is this? And wow, I didn't even know. I'm not in Europe. I didn't know that this applied to me. What's going on? So I think one thing that is confusing is that companies might ask, wait, I'm here in insert Baltimore.
That's
DC,
exactly where I was going
Virginia.
with it. What does that mean to people in the U.S.?
What does that mean? And in fact, twice last week, I got to happily tell companies who asked, you're not subject to it, or I think you're not based upon what you're telling me.
Right.
And that was great news. And I think it's probably news that does affect a lot of companies here who might be worried that they have to, suddenly expend all sorts of resources to get compliant. So I think that that's probably a good place to go now in terms of what we're going to talk about here. You might ask, so how does it apply?
Yeah.
So it mainly applies, I would say, in two areas, and then there's a third that is unlikely to come up, but I'll mention it.
Okay.
So one is if a business has a presence in the EU. So that's kind of your typical business operating in the EU. I've got a storefront. I've got some sort of business. I'm regularly there. I have a presence of some point in the EU, and that would cover many global businesses for sure.
Sure.
Second is, and this is where a lot of the U.S. businesses get drawn in, is if I'm offering services to people in the EU. And what can that be? That could be you've got a website, web-based business. Let's say you're selling beach towels,
right?
And your beach towels can be sold across the U.S. and you ship them, You ship them overseas to the EU.
Right.
You process the currency in the EU currency. You advertise wherever, EU radio stations, but basically that you are actively seeking business and taking business from the EU,
Sure.
that there's some sort of actual connection between you and EU businesses. So if you're just a regular US business doing business in the EU, in the US, not seeking out EU customers, not advertising, not taking sales in that currency, not looking for those customers, you should not be covered by the GDPR, because
Great.
that's not your customer base.
Great.
If you happen to have a blog or a website, and let's say somebody from the EU happens to sign up, well, they're signing up, but you were not going to them.
You're not actively pursuing them.
Right, you're not actively pursuing them.
Let me ask you this question. So this is a real life, I'm not going to give the name of the client, but I have a large client that's in the DC metro area. They are a large accounting firm, and they deal with nonprofits and government contractors. 100% sure they have people all over the country but they're actively looking for DMB, GovCon, and nonprofit business, and I'm going to refer them to you, by the way. But
okay.
But we have been batting it back and forth here in the office whether this applies to them or not, and I think that's a very interesting gray area, because it's clear that the companies that they do audits for, books for, if they're a GovCon and they do stuff overseas, because I know one of their clients because they're also a client, I'm not really asking a question, just more giving you a scenario of that's one of those pieces where you can draw a line and it might not directly go to EU, and they're certainly not marketing to EU folks, but they're doing business with a company that is a subsidiary in the EU potentially. And how does that deal with our marketing database and our strategy and all those other things?
Right, and and there are some factors that are spelled out in the regulation. Like I said, some of it is, is it directed? Is there a currency exchange, et cetera? And I think that is one that's going to have to be explored some more in terms of future interpretations. What we like to say in the law sometimes is when it's not clear, but they rely on kind of looking at various factors. We say it's a totality of circumstances test, and so that would be viewed as to, are there circumstances there that we think that personal information of EU residents is significantly impacted, and they know that they're getting EU resident information, et cetera, as opposed to kind of a random coming. There was one, I'm on a privacy association message board, and there's a lot of traffic, as you can imagine, every day with questions. And there was one a few weeks ago that I thought was interesting, and it was from somebody at like a small health center in, I don't know, Colorado or something. And they said, well, what happens if someone from the EU, like a French resident, is skiing at one of the resorts and gets hurt and comes to our medical facility?
Great question.
Right?
Yeah.
And they said, of course, we would normally comply with HIPAA, which we have to under U.S. law.
Right.
But does this mean now that we're GDPR subject because we've got this French guy, in the emergency room? And I think, and there was some back and forth, but I think what somebody said was, I think is a small regional place where you're not holding yourself out looking for
It's pretty clear they're a
people.
Colorado urgent care. And
right. He came to your doorstep. You didn't go and search. But somebody made a good point, was they said they would distinguish this place from, say, one of the larger teaching hospitals, like say
Sure.
Mass General or Cleveland Clinic. And I don't know if this is true, but they said where they do advertise outside their markets to say, we have renowned experts.
Yeah.
If you want a second opinion, you need special treatment, come to us.
Sure. Or
And
John Hopkins here in the DC Baltimore area, where they're
Right.
bringing in people from all over the world to get treatment.
Yes.
That's part of their thing.
And maybe soliciting, advertising, seeking out EU residents. And I thought that was a really important point.
It's a caveat. Yeah, no.
And useful to think about those two distinctions, where someone like passively appears to be giving you information in the case of the Colorado small
Right.
health center, as opposed to a larger business that is really seeking out the
Sure.
EU residents.
Yeah, that's a good distinction.
something to-
I think that drives us into, sort of consent, and that seeming to be the catch-all. Let's take that Colorado urgent care with the potential French patient. is it as easy for them to just wipe his data? Let's say they have an automated system where he checks in, he fills out the consent form, there's a privacy thing saying we could market to you, it goes into their email bucket, and he starts getting a drip campaign. Is it as easy as them not putting him in their system and him not being anything but a patient in real life, but not digitally, and they're clear as that one example? And then the second thing is, does a consent seems to be sort of the catch-all to help keep companies and marketers safe, is how do companies implement that to maintain their compliance? Because, that's really what GDPR is. We can interpret, we can certainly have conversations that make sense to see, oh, they're not marketing in the EU, this guy just showed up at their doorstep. But really, if there's preventative measures, that's what I think really people want to get in front of. That's certainly what I'm going to advise my clients to do.
In the case of, we'll call him Jacques, in the case of Jacques, who appears with his poor broken leg in Colorado, do you like how we've developed our Pierre, Jacques, who broke his leg and now appears? I mean, I think that at that point, in that facility in the U.S., I would say they should go through their normal procedures that they would do for HIPAA. And would I kind of take him off of our marketing? Would I take him off of our marketing list to the extent they are doing that? I think the best thing would be just to not include him, because if there's ever an issue going forward with anybody else, you could say our policy is we of course treat the person who's appeared, and we abide by our HIPAA laws, which we have to, but we are not looking to engage further with the EU residents. Also, they're really, when it comes to consent under the GDPR, it has to be freely given and affirmative and not lumped with other stuff. And not conditioned to obtain a service. So I think if poor Jacques or Pierre comes and he's in pain and he wants service, and in terms of giving him all the forms that you get when you go for medical procedures, if there's some thing in there about consenting to receive, promotional or marketing emails, I'm not even sure that's going to be effective under GDPR, because it may be bundled with the service, and obviously he's under some amount of pressure and stress in that situation. But that's a unique situation. But in terms of just kind of other businesses who are GDPR subject or concerned they might be, there are, consent is a valid way to market to someone. But there, like I said, there are certain requirements for the consent.
And that's no more pre-checked boxes, right? No
more pre-checked, right. And I would say even under U.S. law, there are some aspects of U.S. marketing law, like when we get to Telephone Consumer Protection Act, and we could do a whole separate series on that. But, certainly on U.S. law, there are certain requirements that you have an affirmative opt-in for certain types of marketing. Okay. And even under U.S. law, I always have said, and I've got PowerPoints that say, do not do a pre-checked box, because that to me isn't necessarily affirmative. And I would have an easier time defending a company where someone had pressed a check or clicked a check or pressed enter. But definitely on the EU side, they have made clear under the GDPR that pre-checked boxes or pre-checked anything is not consent. Someone has to affirmatively check the box and opt in, and that way you'll show that they did it. Hopefully, the system can record that they checked it and when they did it. It's supposed to be separate from other materials. So just lumping it in a 15-page terms and conditions,
burying it at the bottom isn't work.
Right, is not good. You want it to have it separate and clear. People are supposed to understand what they're consenting to. So are they consenting to just newsletters, or might you be sending them other things too? So you need to explain that they agree to receive whatever it is, promotional materials, emails, and specify what it is, emails, texts, or what it might be. I mean, when I'm getting consent, even here on the U.S. side, I try to envision, I don't want to limit it to we're just sending you emails if they might want to send texts.
Right.
So to be broad about what kind of and explain to the citizen, the resident, what kind of information is being collected, that it's clear, it's unambiguous. They opt in. The other thing that's really important, and we have it under U.S. law too, on can spam, is that you have to have the ability to opt out. So you have to tell people when they're opting in on the European side that they have the ability to opt out and how they do that. Okay. And then going forward, when you send them something after they've consented, each time you send them, just like in the U.S. actually under can spam, they have to have an opt out. And it has to be easy. It can't require them to take several steps. It can't require them to do this complicated or any login.
Right.
They should just be able to press, like we do with most, I think, legitimate marketers now. Unsubscribe. On the U.S. side, you're able to offer a menu, so you can unsubscribe from everything, or you could unsubscribe from, promotional, but you want to get the newsletter or something. But definitely on the EU side, you will need the opt out, and each time that anything goes out, and of course you need to abide by it. Sure. That's huge. So you have to, when someone opts out, they may have signed. Let's say they signed up because they thought it would be of interest, but now it's they're getting too many, it's clogging, or they're not interested in what you're offering. So they opt out. You have to respect that opt out, and you have to take the opt out. And you really can't at that point. Right. And you really can't at this point just start emailing them again seeking consent. That's also bad.
Yeah.
If they happen to opt in again, like they went to your website and opted in, that's fine. But once they opt out, they opt out. Same as in the US under can spam. You have to offer the opt out, and then you have to respect it.
So give us some next steps for any company that thinks they may, I won't even say thinks they may because they may not know, but any company that is marketing and potentially marketing aggressively or purposefully to citizens of the EU, next steps for them resuming their consent for current subscribers. Do they have to go back in time? They have to review future consent forms. Give us some steps. I'm a company and I'm actively recruiting users in the EU. What do I need to do to get ready and to get right? Not even ready because it's already happened. To get right.
Yeah, it is already happening. So some of this ideally would have been done before. But I think step one is determine, do we think it's applicable to you? That would be step one. Step two is assess your email list. Where did you get these from? And did you have consent originally? Did you just, are they data broker lists? Those are not going to be consent lists.
Not good.
Were they good lists where you've got a website and you've got great content and people sign up for more? So did you, especially on the EU side, if they signed up before and they at the time you told them about the option to opt out in the future, that is pretty good consent, and it's possible to email and ask for soft consent to say, hey, we're on your list and we want to make sure that you want to continue to receive. There are companies that will just kind of go now, with their list that may be iffy and try to seek consent, but technically that's not going to work under GDPR because that's kind of like prospecting for consent, which is not consent. It's really a promotional item. So that is, I know that that's going to not put some people in a happy place. Sure. But that's sort of what the law is meant to do, is to tighten it. Yep. Of course, if you want to go on the U.S. side, you are able to, it's the can spam law, which I always say means you are able to email as long as you offer the opt out. But you can't go prospecting in Europe at this point. You really kind of need to go back and try to figure out, where did I get these email addresses or phone numbers or whatever it is? And do I feel that there was proper consent at the time that I got it? And I think for a lot of companies, they're not going to be sure. So I think that some are staying away. Yeah. Some tried to do that routine last week to go and see, and I think companies are taking different approaches. I had one from a university that said for EU residents, we're getting ready for the law, and if you don't indicate that you want to receive information from us, we will not be emailing you.
Yeah.
At all.
Yeah, no, that's interesting. I shared an email that I got from London Heathrow Airport. I've been there twice in the last 18 months, so it was legal. One of the guys in my office, Ian, who lives in Northern Virginia, he had not been through London Heathrow in probably 7 or 8 years, and he got the email. And the conversation was, are they even legally allowed to send that to me as a non-active in the last 18-month user? But they figured that part of it is superseded by the GDPR, we need to let everybody know piece. And for nerds like us in our office, we were geeking out on that for 20 minutes, just having that what if, which one's more important and which one's more of a violation than the other. But it's funny to see where things are going. And you're right, it's, hey, I'm sending you this and I'm never going to send you anything again. Heads up that I'm out of your life forever. Where, the other thought is just delete them, purge the data, and be done with it that way. But the sending the email, to your point, saying, hey, I'm never going to email you again unless you do these things, you'll get a percentage of people that say, hey, yeah, keep me around. And then their bucket goes from 0 to whatever that percentage is. So at least they're in the positive on some level there. So, it's.
Yeah. And there are some companies that recommend periodically, re-upping. So let's say you feel like you've got your good consent list now.
Yeah.
Or whatever, 6 months from now or 9 months or a year, and to say, hi, we want to make sure that you've been enjoying our materials and they're not clogging your box. I've seen people do it very creatively, and they're not clogging your box. Click here, and we'll continue to send you. If not, we won't.
If my staff brought me that idea, I would tell them no, unless you have an amazingly creative way. And I would approve that if it was to a list of. It was a segment of a list that I knew wasn't getting engagement, and this is a last-ditch or second-to-last-ditch effort to wake them back up. I would approve that all day from a creative standpoint. But an active, ongoing list, I would never put the thought in their head that maybe we're troubling them by emailing them if they're already engaging. But that's a whole nother topic. You and I can discuss about the strategy of audience consumption of an email or a text or what have you.
Right. And and even
people pay us too much money to talk about that for free.
Exactly. I was going to say, and even on the U.S. side, where we tend to be more litigious from a private plaintiff side than in Europe. One thing that when it comes on the U.S. side that, I've definitely recommended for some clients is, whenever they have a touch with a customer, the customer calls into, customer service, or you're sending somebody out, or whenever there's a touch, is to reaffirm the phone numbers, the contact information, because that way you're getting updated information. At least on the U.S. side, consent can also be a recording. As long as people know they're being recorded, which is a whole separate series of laws. But when another series for us. But whenever they have a touch, is to confirm, this is still your mobile number and this is the number that you want to be reached at, for us to send you information on, et cetera. So there's another way, depending on the business, but when there's an actual interaction, whether it's an inquiry or follow-up, et cetera, is to re-engage that customer, to check, number one, just to confirm their contact information, and then two, to kind of, reaffirm that consent. So that's good certainly for existing customers, for sure.
Yeah, no, that's great. Michelle, thank you very much for the time. Before we wrap, is there anything else that we need to go over that we missed about GDPR that we need to know? And of course, in there, let people know how they can get a hold of you, more information for you and your firm, and how people can reach out to you guys.
Sure. I think that there's a couple of things that we should just wrap up with. One is consent, as we've talked about, is so important. So it's key to maintain that. Make sure that you or your vendors give you records of consent. If you're relying on consent and a regulator is coming to you to say, what's this blast you did, or you've got GDPR issues, or even on the U.S. side, you've been sued in a telephone consumer protection lawsuit. If I've got someone's consent, well, that's a nice way to make those plaintiffs go away. And so if whether it's GDPR or here in the U.S. or someplace else, you want to make sure that you can back up your consent. You definitely, as I mentioned, comply with the opt-outs. I mean, typically, what I've seen over the years is are you going to get sued the first time your opt-out doesn't work? No. But if someone's like getting constant calls or emails when they say, I was so annoyed and I know I opted out, because I have one I do have one in the US that keeps emailing me. And I was like, I know I opted out of this.
Me
and normally
too.
I would care, but I'm like, come
11
on.
times.
Right.
So literally. 11
in the US,
times.
it's supposed to be within 10 working days that you implement their CAN spam. So it's good practice wherever you are that you've received it and you've implemented it. And when it comes to fines in Europe, which can be huge under the GDPR, it can be up to 4% of a company's worldwide revenue the year before, which for a big company might be ginormous. One of the factors that they'll look at is, what efforts did you put in place to comply with GDPR? So if you're just a company that's like, we didn't do anything and you have nothing to show for it, that's going to be a problem. But if you can say, we had compliance mechanisms, we only emailed people we had consent from, we offered the opt-out, and this time in this campaign, there was a there was some catastrophic glitch, well, that's going to be helpful, but you need to show compliance. I think otherwise, so much of this is we have this big law and we have some guidance from the different EU regulators, but so much of this is going to develop as the regulators do issue enforcement orders or other statements. So I think stay tuned, keep reading. We offer a lot of free info on our blog.
Yeah, sign up for that legally, please.
Sign up for that legally. It's ifrahlaw.com, and you can link to the blogs from there. I'm on Twitter at Michelle W. Cohen, Cohen, and I post things there. I post things on LinkedIn. People can link with me there as well. And I think, so much of it, I am on this listserv, and we get a lot of information there. But a lot of it's just kind of each of our opinions, and a lot of it is going to really gel out as the law gets implemented and gets enforced, and then we'll have cases. We'll have we'll say, oh, this is similar to the XYZ case, and over there the company showed that it did have valid consent, or it did take the opt-outs, etc. So I think part of it is just going to be staying aware. I always tell people, read. There's a lot of good materials out there. There's a lot of confusing materials, but if you look at the materials from law firms that do a lot of privacy work like ours, and some of the regulators, the UK regulator is the ICO, the ICO, they have a lot of very good materials available, and the IAPP, which is the Privacy Association, International Association of Privacy Professionals. Some of theirs is behind a firewall for members, but some of it is also available, and they're preeminent, and they do a great job of information. So just keep reading, and feel free to link with me or follow me on Twitter. I might have mentioned earlier, I have a rescue puppy named Joey, and I'm making him Joey the GDPR dog. And he will be spreading the good word of GDPR to kind of keep things interesting. That's
amazing. Yeah, we can't wait to get some precedents on the book so we know sort of what the target is and for things to solidify. Michelle, your time's been amazing. Information's fantastic. Sure. Thank you very much for your expertise. We'll make sure that we connect offline with some other stuff that we want to pick your brain about, and potentially refer you a few clients that need some of this help in the accounting space and in the HIPAA and medical space. So again, we thank you for your time and your wealth of knowledge.
Thank you. Have a great day.
Michelle, you too. Thanks so much.